How do I go about filing a domestic violence restraining order in North Carolina? Hello, my name is Jonathan Breeden, the owner of the Breeden Law Office, and my office has been helping families in Johnson, Harnett, and Wake counties for over 20 years. The first thing you want to do if you think you need a restraining order in North Carolina is go down to your local clerk of court's office in whatever county where you reside or where you may be staying temporarily and ask to be able to file a domestic violence protective order. The clerk's office will give you a blank complaint which you can fill out. It's a form from the administrative office of the courts for you to be able to ask the court to grant you what is commonly known as a 50B restraining order. Most courthouses have domestic violence victim advocates at the courthouse during the day on most days to also assist you with filling out your complaint for a domestic violence protective order. The clerk's office cannot provide assistance other than to hand you the document because they cannot give legal advice. But these domestic violence advocates that are there almost every day at almost every courthouse can be a great assistance in filling out a domestic violence restraining order. You can also call your local legal aid office and they may be able to provide some assistance, or your local domestic violence shelter in Johnston County, that's Harbor House, in Harnett County, that is Safe House, and in Wake County, that is Interact. And they can also help you in filling out your domestic violence complaint with the courts. Once you've filled out the complaint, you will be taken in front of a judge either in person or via WebEx to explain to the judge why you need the restraining order. The judge will ask you a few questions, review what you wrote, and if they believe that you've alleged enough to be granted a restraining order, they will grant you an immediate ex parte restraining order that is valid immediately, and it will be good for up to 10 days. You will then be given a court date by the clerk of court within 10 days of the hearing that the judge granted you this immediate restraining order, when you will return to the court after the other party has been served, and you will have a trial with a judge for you to prove why you should have a restraining order for a year. If you were successful at that hearing, you will be granted a restraining order for 1 year. If you have any questions or concerns about how to get a restraining order, whether you have enough information to qualify, you want representation in helping you win that return hearing after you've been granted the 10-day order, give me, Jonathan Breeden, a call at 919-661-4970 or reach out to me at breedenfirm.com. We want to help you be the hero of your life story.